This is Jeffrey Davis, and so welcome back to Radio Entrepreneurs, and glad to say we're airing from our great new internet studios, 119 Braintree Street in Allston, overlooking the Mass Pike and the commerce of Boston. Every week we like to discuss business and the law, and if we're discussing business and law, we're clearly talking to Mr. Furman, Mark Furman of Tarlow, Breed, Hart & Rogers. Welcome back, Mark.
Hello, Jeffrey. Great to be with you.
Mark, there's no lack of legal activity and going on in this state. What is the important story of the day?
Well, this time of the year, the Supreme Court, it's the end of their term at the end of June, and occasionally they decide cases that aren't business cases, but I just think are so important. So this happens to be one of those days. I'm going to talk about a non-business case, and that's the Supreme Court decision in Riley versus California regarding whether or not there needs to be search warrants when folks are arrested and they have cell phones on them. So it's very rare that the Supreme Court decides a case unanimously.
Right.
And the Supreme Court just came down with a very important decision that upholds the privacy that we're all entitled to under the Fourth Amendment. Issues of privacy, though, are important issues in business, too. So let me just kind of switch over to that. You know, sometimes people want to record phone conversations or meetings with an adversary in business. In Massachusetts, that's illegal without the person's consent. That's a crime. The federal government has a law as well, not quite as strict as the Massachusetts law. Massachusetts has a very strict law protecting privacy. So when you get into a dispute, don't record your adversary's conversations without their consent. It's very important to obey the 24-hour rule because of this. You know, in a moment of anger, you can say stuff in an email that maybe you wish in retrospect that you didn't say, and your opponents in litigation, you know, they just want to get at the emails. I have found that there are people who are just very anxious to not have any loose ends on their email, that they're, you know, if there's an incoming email that needs a response, they want to get it out and get it off their plate. But when you're in a contentious potential litigation matter, you really want to take your time and cool down and reflect on exactly what you want to say. And just assume for a second that a judge or a jury is going to be reading it.